Involvement with the criminal justice system is life-changing. It matters.
Having a justice system that works is a really important part of a democratic society.
I'm Penelope Gibbs, Director of Transform Justice.
I'm Rob Allen. I've worked in and around criminal justice all my career.
This is the Transform Justice podcast, throwing light on the criminal justice system.
Hearing from people who know.
It's about whether the system's fair
and what can be done to make it better.
Hello. Today I'm the sole host since Rob is on holiday. I'm looking forward to discussing a very current issue, how the police and courts deal with protest, with two absolute experts. Sarah Lunnon has supported causes such as Just Stop Oil and Insulate Britain. Audrey Mogan is a criminal barrister who has defended many a protester. Audrey, you most recently defended Niamh Lynch, who was accused of throwing orange powder over Stonehenge. Did you win the case?
Yes, Niamh was acquitted. All three defendants in the case were unanimously found not guilty by the jury.
So they didn't do it?
Well, they didn't say that they didn't do it. They had these colour blasters, which just basically let out plumes of orange powder. Some of it went on the stones at Stonehenge, and they sat down and then waited to be arrested. So they never said that they didn't do the action. What they said was that their actions were such that they had thought about the kind of material, and it was so important because what we're talking about is a crisis that is affecting the entire planet. Niamh talked about, we look at Stonehenge, we look at the stones, and this is legacy from 5,000 years ago. What will our legacy be in 5,000 years, given what we're doing to the planet? Those are her words, not mine. And what they said was this was a lawful exercise of their right to protest. So prove to us it isn't. The consideration of whether effectively they went too far was left to the jury to consider. Importantly, because this was not said in the media, even the lichens on the stones, there were expert reports to say that there was no damage, nothing to impact even the lichens. Niamh is an ecologist. She's a climate scientist. She would never have done it if it would have any kind of impact like that. And so there was a number of different defences, including the right to protest.
And were they campaigning under the Just Stop Oil?
It was a Just Stop Oil protest, yes.
Yeah. Sarah, when did you start getting active in the sense of environmental campaigns, doing things which could be seen as protesting?
Oh, that's a good one. So we had a proposed incinerator where I live in Gloucestershire, and I think my first taste of what you might call an action, making life difficult for the authorities, was around the proposed incinerator.
So what did you do?
So I didn't take part at the time because I was an elected county councillor, and I had this idea that I would be more effective as the councillor in the chamber taking action than being arrested, which I rather regret. But I was highly involved with a group that was taking action that locked on in front of the site of the incinerator.
What, locked on? Can you explain that?
People actually use devices such as bicycle chains, bicycle locks.
To lock each to one another. So
to
there
lock
was
themselves
a chain
to each other, or just a sit-down protest. And refusing to move so traffic couldn't move in and out of the site. So that was my first real taste of what you might call an action outside of politics.
But were you a wild teenager in trouble with the law? Or is the first time you've ever been in trouble with the law through your campaigning activities?
Yeah, it would have been in my 50s when I first got arrested. So no, I was always a good girl. I took part. I believed in democracy. I believed that voting would solve our problems, that reasonable people would take reasonable action to address environmental concerns. I brought all of that until about my mid-50s when the realisation that if our current system of voting and representational government was going to solve the problem, it probably would have done it 50 or 60 years ago. And every single indicator was getting worse on the climate, environmental, planetary crisis. So something else needed to be done.
So Sarah was in her 50s before she was arrested and had never been in trouble with the law before. It must be very different defending protesters like Sarah, whose activities also are in plain sight a lot of the time and meant to attract publicity from other defendants who are often, doing what they do, definitely not in plain sight.
It is different. It's, yes, I did this, but this is the reason I did it. The direct action protest movement generally is going to be certain people from certain ethnic backgrounds, certain ages, because of the difficulty trying to do that as young people of color who are definitely targeted by the police more often. So just to say, that's always something that you recognize when you do general crime work and then you do work defending protest people, because really being able to put yourself on the line like that really isn't available to everybody because of the way the justice system works. And what we've seen over time is kind of a clamp down on the right to protest. Sarah mentioned locking on. That's such a fundamental way in which people have protested throughout history. And recently that's become a separate criminal offense in and of itself, where it wasn't before. That's the trajectory we're on. And that was because they were bringing in a number of offenses that were clamping down on the right to protest, including locking on, including the offense that Neve and her co-defendants were charged under, which basically meant that serious harm was defined as serious distress, serious annoyance, and serious inconvenience. I mean, we're talking about criminal offenses that are going to have long-standing impacts on people's lives.
And, I mean, there is a long history of non-violent protest in this country. So you had the Greenham Common camp against nuclear weapons, you had Occupy, you had Swampy, the environmental activist. Say Greenham Common, would that be allowed today? I mean, they camped for years outside an airbase to protest against nuclear weapons. Is that something that could happen today?
What we're seeing happening even as we speak is the police have these powers, which mean that they can put restrictions on protests, whether it's the procession or basically saying to you, okay, it's time to disperse, right? What is now being tabled is an amendment to that to say that the police can look at the cumulative effect. Now, that's clearly and obviously being done because of the Palestinian solidarity campaigns, but it would similarly have an impact if you've been there for years, 25 years. Common. Yes, exactly. Yeah. They could use those powers because of the cumulative effect of those powers to disperse them. So I think very clearly they would try to clear them out.
They were also breaking into the bases as well at Greenham Common. One famous time they were dressed up as a loaf of bread running around the airbase. The equivalent of doing that now would have really serious repercussions. So we've seen what's happened when people were planning to cut the perimeter fence at Heathrow and Manchester, for example. They were treated really quite harshly by the courts with very long prison sentences handed down.
Was that meant to draw attention to the climate catastrophe again?
That was Just Stop Oil action. If you are acting now on an issue which is the future of mankind and life on Earth, the government is taking step after step to take away any avenue of protest or actions that people find to make their voices heard, while denying you the ability to defend yourself in court. The laws are being changed, but also the environment in the courts has changed markedly. So people now are ending up in court. If they say the words climate change, they will go to prison for contempt of court. At least 4-5 people have been sent to prison for saying climate change in a UK court, because your ability to explain context and motivation is taken away from you.
But presumably they're not just being sent to prison for saying climate change. They are accused of a crime that our parliament has enacted as a law.
I think what Sarah's kind of saying is that in some cases, if a judge says, well, actually, your right to protest is not going to afford you a defense in this trial, some judges have taken the view then that whatever you have to say about why you were protesting is irrelevant. And then if they start giving evidence and talking about it, people have gotten warnings. I've never had anybody then sent down for contempt. But I think what you're talking about is not just then you get convicted and you get a prison sentence.
I understand.
It's the idea
it's
of
contempt of court.
Yeah.
It's that the judge in those cases said, you will not use your cause and you will not talk about it and you cannot use it in your defence. And then the defendant says something which defies what the judge said, they're then accused of a completely separate offence, aren't they? Which is this offence of contempt of court.
And it's really interesting because you don't see that happening in any other kind of criminal case. This kind of, let's talk about what defences you have before the trial is even started, before one piece of evidence is even being called. The suggestion is, let's see what defences you're going to run, whether you have them. It just doesn't happen in other criminal contexts. And as we've spoken about, it's a lot of people that haven't been in trouble. They aren't people who are necessarily familiar with the criminal justice system. And to go and then have to give evidence, to talk about something you did without being able to explain at all why you did it is just so unnatural that it is completely confusing and laughable, really, that would be done. In many cases, judges, even if they remove a defense, will say, okay, well, you could talk about it. But there have been judges that have effectively said no. And the concern is that the reason for it is that if 12 members of the jury hear what you have to say about this important issue, whether it be the climate, whether it's Palestine, whether it's during the Black Lives Matter marches, that sympathy can lead to acquittals even where they say that there isn't a defense. You know, I'm not saying that anyone has said that that's the reason, but you do wonder when you're in a court, and I do regular crime all the time, and it's just such a world of difference between the two.
So Sarah, you've been in court, haven't you? Accused of crimes related to your activities. What was the offence you were accused of?
I was arrested under a new law for interfering with national infrastructure by stepping off a pedestrian crossing at Trafalgar Square and stepping into Whitehall. I spent 90 seconds on the road and I was arrested for interfering with national infrastructure.
What was the national infrastructure? Sorry,
the road.
I'm not... The road, okay.
Yeah. So if you walk on the road now in the United Kingdom, which is what people have done for thousands of years to make their point to whoever is governing them, you can be arrested after 90 seconds. That's how draconian the United Kingdom has got. However, I was charged with obstruction of the public highway, which is a much lesser offence, because I think they did not want me to choose to go to a Crown Court with a jury and all the expense that will take up.
Yeah, so the maximum penalty for your case meant it stayed in the magistrate's court. Yeah. Were you restricted in what you were allowed to say?
No, you don't tend to get restricted so much in the magistrate's courts because there's no jury. The magistrate's deciding. The restrictions usually happen in the Crown Courts where there is a jury. Mm-hmm. And it's really interesting. There's a case of people who climbed up on the gantries on the M25. There's two cases, one in September in Guildford, where the judge actually let people have a defence of reasonable excuse.
Yeah.
And they got found not guilty. And then one has just happened in Southwark for exactly the same action, for exactly the same charge, and the judge refused to allow reasonable excuse, and they were found guilty. So all of Just Stop Oil trials, where we have been allowed a defence, we have been found not guilty, because people have been able to explain their actions, and also you can put evidence forward. Because if you don't have a defence, you're basically operating in a context-free environment. You've done this crazy thing and you cannot explain the context and the scientific facts that have led you to taking that action.
And usually there is video footage which shows that the action took place.
Nobody who has taken action with Just Stop Oil has denied that they have taken that action.
It's about accountability. But yeah, I was just going to say, sometimes there have been defences of, I wasn't a part of this. This was a wide sweeping arrest.
Yeah. And interestingly, at the moment, I think we're running at about 30% not guilty verdicts, with people turning up and saying, yes, I took that action. Here's why I did it.
So of the Just Stop Oil court cases, you're saying around a third the defendants have been found not guilty, but that still leaves a huge number.
Oh, absolutely.
Guilty.
Yeah. Who haven't been able to mount defences.
Yeah. So you mounted a defence. What happened?
Oh, I got charged with obstruction of the highway. It's quite difficult to prove obstruction of the highway if you're only on the highway for 90 seconds.
You're found not guilty, yeah?
Yeah.
Okay.
Yeah.
I was like waiting with bated breath.
Yeah. And in terms of that court case, did you have a lawyer?
No. So we all represented ourselves in front of the judge.
Why on earth?
So it is really useful to have lawyers on hand, right? It absolutely is, because they understand the law and the detail and the systems of the court, because court is so technical. But also it's very difficult for lawyers to resist the court and the judges, because it's incredibly hierarchical.
In what way?
Well, you can actually push back against the judge.
You mean if you're an individual, you
If
can
you're
push back?
and you're representing yourself, you can say, no, I'm not going to stop talking. I'm going to carry on making this point. If you've got a legal representative, they are not going to do that for you.
So
I don't know
are you
what the
saying you've got more
repercussions would be.
freedom to speak if you represent yourself?
Yes, you do have more freedom to speak. And also, it's cheaper. Because if you have no access to legal aid and you were called up before a Crown Court and you want representation, it costs a lot of money. And some of these court cases have gone on for 3 weeks, even longer. I can't remember the Heathrow one, 8 weeks.
Yeah. And I don't think a lot of people know that. In fact, I know that lots of judges don't even realize that. So sometimes there's this idea that, oh, these protesters, they're coming just to cause a problem. That's why they're representing
without lawyers.
Exactly.
Yeah.
But actually, the contributions that you have to make. So if you've, worked your whole life, saved up money, bought a house, and then you're in this situation, they can come after that. And a fantastic solicitor, Laura Bryan, she's the one who explained it, not just to me, but to the judge in our case. Because he kept saying, you should get lawyers, you should get lawyers, you should get lawyers, as if people weren't getting lawyers just because...
Just because they were being difficult.
Yeah. But then when she explained it clearly, I think everybody was a bit shocked about the impact. Even if you get legal aid, the contributions that you would have to make if you were found guilty, it forces you to have to represent yourself in a situation where there is a lot of legal jargon.
But it sounds to me, Sarah, that it's partly because of the difficulty of getting access to legal aid and the cost of it, but you're partly wanting to represent yourself as a sort of principle because you're worried that the lawyers are kind of part of the system, as it were?
Yeah, they may find it hard to say exactly what it is that you want to get across, to tell your truth to the jury. It can be very hard for them. So if you aren't represented, you have a better chance of doing that. Although there are some issues which I think the court also is grappling with at the moment, because more and more people with Just Stop Oil at the end of our campaign were being held on remand. So that is, they were being held in prison.
Pending their trial, and they were representing themselves from prison. So it's very hard to actually make sure you've got all of the legal documentation. It's hard to get the information and the legal arguments you need. You've been transported to court from prison. You're in the dock. You have no table. You have nowhere to put your paperwork. And also, you can't hear. The hearing in court is appalling. At one point in one of the trials I witnessed, the prison officers wouldn't let the people self-repping have a pen because policy was they weren't allowed pens. I mean, in terms of an unrepresented defendant, Audrey, obviously you would recommend as a...
No, but I don't disagree with anything that Sarah said. You're right. We're lawyers. We are a part of the system. And there are things we just can't do. Even the most activist-y lawyer there is still has to work within that system.
So how are the judges managing, say, an unrepresented defendant in the Crown Court?
Yep.
They can't really stop them speaking and cross-examining witnesses how they wish to, can they? Because that person doesn't have a lawyer.
Well, this is the thing that the judges will always say to them. They're still under the same restrictions that a lawyer would be under. It's the judge's duty and the Crown's duty to assist in the sense that making sure that that person has all of their documentation, which I've seen is shocking.
You mean a shocking lack of
Shocking lack
documentation?
of documentation and real concerns about whether these people have all of the material that they need. And a judge is also responsible to make sure that they understand what's going on. What they do say over and over again to the self-representing defendant is you still are bound by the rules that a lawyer would be bound by. That's true, but I guess it's easier for self-reppers not to listen.
So Just Stop Oil have hung up the high-vis and stopped doing direct action. Was that partly because the criminal sanctions involved, if you get convicted, have got so much harsher?
It's a really good question. The Labour government had agreed to end new oil and gas in the North Sea. So that demand of Just Stop Oil had been met.
Yeah.
The legal environment had changed a lot, but actions still had taken place in 2023. I think any campaign has a lifespan, especially a direct action campaign, especially one which was as disruptive as Just Stop Oil, was as high profile as Just Stop Oil. And the next campaign will operate in this very different legal landscape and will take notice of that. In some ways, you can see it as a game of cat and mouse, I suppose, between the state and those who want to, oppose and resist the state. So another campaign will be born. But I think the Just Stop Oil campaign had a lifespan. New legislation was brought in. The use of injunctions, which is basically a private law taken out against individuals.
It's civil law as opposed to criminal, yeah. So what we're talking about, orders saying people can't go
somewhere.
Particular places.
So, for example, Kingsbury Oil Terminal. So they had an injunction there, and the idea was you can't go there. You basically can't protest on that site. And so if people go and you break that order, there are costs. Unlike in the criminal courts, where they can require you to pay costs if you're found guilty, they're a lot significantly lower than the kind of civil costs you would get.
Oh, it's tens of thousands of pounds.
Yeah.
And you can be sent to prison for breaching the injunction as well. So people were sent to prison for standing on grass outside an oil terminal. That broke the terms of the injunction. They were sent to prison for it. They are then named on the injunction and they have to pay costs.
And there are individuals who will both have their names on an injunction and maybe facing proceedings in the civil courts for breaching that injunction, whilst also having a parallel criminal case for the same act. From a judicial perspective, that's not being charged twice for something, because one is the breaching of the injunction and the other is the criminal law, but it is the same act. And the UN Special Rapporteur, Michel Forst, on environmental defenders was quite scathing about the UK's practice in doing this and the clampdown on the right to protest.
And sometimes the bodies taking the injunctions out are government bodies, like National Highways Limited, Transport for London. So they are actually national government bodies.
My understanding of injunctions is it has to be done by either the state or a state-agreed body.
No, the oil terminals, the oil companies have taken out injunctions as well.
Oh, have they?
Yeah.
But it still has to be agreed by the civil courts. It does.
A judge has to agree it.
Yeah.
But it can be private companies.
Yeah, I understand. They can apply for an injunction and it's the civil court that agrees it. In terms of post-Just Stop Oil, Sarah, most recently you have been accused of terrorism offences, the most serious yet. What did you actually do to be accused of a terrorism offence?
I sat on some grass with a cardboard sign.
And what did the sign say?
The sign said, "I oppose genocide, I support Palestine action."
So you sat there and then?
I sat there for quite a long time, hours and hours, and there were police lines, but you could just walk out from the police lines and then walk back in again. And yet I was arrested under the terrorism legislation. And I think it makes a mockery of the terrorism legislation that I've been arrested under it, and yet if I chose to, I could have put my sign down and walked away and I would not have been arrested. So are you breaking the law or are you not breaking the law?
Audrey, terrorism offences are very serious in law indeed. How are lawyers challenging their use in terms of the Palestine Action organisation and activities?
So lawyers, myself being one of them, are challenging the decision to prescribe Palestine Action.
To call it a terrorist organisation.
Exactly. Yeah. And that is underway, and we've been given what's called permission to challenge it. And that will happen on the 25th, 26th and 27th of November of this year.
But I know that the decision will be quite a few months after that. Yeah.
Yes.
Meanwhile, what's happening to the people? Because there's hundreds of people who've been arrested.
Thousands.
1,700, I think, and counting. Well, I guess they're in a little bit of a state of limbo. Some people have been charged. I think the first trial will happen in March of next year.
But we don't know, basically.
We don't know.
So there seems to be a bit of limbo in the system, because quite often when people are arrested, they're charged and dealt with very soon. But because this is a terrorism offence, it must be the Crown Court, etc., etc.
Well, not all, because there are some offences under the terrorism legislation, like having an article displaying a sign supportive of a prescribed organisation.
But why is a terrorism charge ending up in front of a magistrate's court?
No, I'm surprised as well.
But that isn't specific to Palestine Action.
No.
So that is part of the legislation.
Yeah.
Right? And it's simply this point, which is you're wearing a symbol. It's a low-level offence. The sentence you could get is one only dealt with in the magistrate's court, and that's why it stays there. And that's not specific to Palestine Action.
But it looks like the whole system has put this stuff on hold, because in order to cope with it, if this all does go ahead, it will be a huge amount of work to deal with all these defendants.
Yes, definitely.
I think there's a report as well in the New Statesman from a committee that was set up to look at the Terrorism Act as well, basically saying that the legislation is drawn too widely and too loosely and needs to be reformed. So I think one of the things that has happened because of the protests after Palestine Action was prescribed is actually highlighting just how badly drawn the Terrorism Act is.
Because what happens effectively is under Section 1 of the Terrorism Act, when it was being debated in Parliament in 2000, one of the things that they had included in the definition is serious damage to property, significant damage to property, without any impact on individuals. So I think if you just stop somebody in the street and ask them what they thought terrorism was, almost everybody would say to you that it would have some kind of violent impact on individuals, right? It's terrorizing people. That's the idea. But when they drafted the legislation, they included in that definition purely damage to property.
But if you're holding a placard, you're not damaging property. So what's that offence?
Well, that's different. So in the 25 years that it's been in action, they've never chosen to prescribe a direct action protest group until now. And so that's why there is a lot of scrutiny looking at the breadth of that definition.
Okay, well, we'll watch this space in terms of this Palestine Action judicial review. I mean, I will say, and it relates to Palestine Action, our prisons are full and few members of the public think non-violent protesters should be a priority for imprisonment. So, Sarah, is there a move actually in courts to give more lenient sentences simply because we're talking about prison being full?
We saw with the case with Roger Hallam and his co-defendants, Roger Hallam got sentenced for 5 years.
Imprisonment.
Yeah.
For what?
For conspiracy to cause a public nuisance, and his co-defendants got 4 years. And there were a number of other really severe sentences. Phoebe and Anna, known as the Soup Sisters, they got 2 years for throwing soup over a glass frame of the Van Gogh sunflowers. No damage was done to the
Potential
painting.
damage. I mean, they could have caused damage.
There's no way they could have caused any damage to the sunflowers. They were behind glass in case of things like that happening. But they didn't damage the sunflowers, and they got a 2-year sentence.
I'm just wondering, because we do have full prisons.
Yes.
Well, and
we
also
don't
when
agree.
people are released from prison, the licensing conditions that they are being released under are also pretty draconian. So Ella Ward actually challenged her conditions, and actually they've taken them away.
Yeah.
What was her original offence?
Conspiracy to cause a public nuisance by breaking into the Manchester City airport and doing a protest there. Yeah.
But she couldn't go to any meeting. She wasn't allowed to take a job or work in a particular place because it was considered political. She wasn't allowed to talk to anybody who had any relationship with protest groups. That's really difficult, like to challenge your conditions. So you have to find someone who knows their way around the legal system to do it. You need to either find a lawyer who's going to do it pro bono, or you have to have the money to be able to pay for it. And there are numerous other people with incredibly strict conditions. They are not allowed to go to any meeting. They are not allowed to associate with anyone from any protest group. There are some really draconian conditions being handed out to people.
And also, I would say that I've seen, especially people getting involved in Palestine-related protests, conditions with organizations like Prevent Counterterrorism Police getting involved even before any kind of prescription. So if you're taking part in a Palestine-related protest and you get convicted, and then to be visited by people asking you questions about whether you've been radicalized because you were a part of a protest. And again, I know that this has happened long before actually prescribing Palestine action. So it's quite scary to think.
Yeah, that certainly is. Fantastic discussion. I fear we must wrap it up. And always at the end of our episodes, we ask people a question. So, Audrey, if you were Prime Minister, what one change would you make to how the criminal justice system deals with protest?
I think that when people have protested, it should be a question for juries to decide. In the Stonehenge trial I just finished, the judge said it's people from the community chosen at random who should decide if someone has committed that offense or not. There's 12 of you. Each of you brings something completely different to the decision-making process, so we have a good cross-section of society. That's the point. That's what makes it democratic, as opposed to one individual judge deciding to remove defenses. And I think that's probably the most important thing. Let the community decide. If people have gone too far, the community will tell them that they've gone too far. But if not, then that is simply protecting this democracy.
So just to give context, there are proposals on the table by Sir Brian Levison to restrict the use of juries and to have more cases dealt with by a panel of a judge and 2 magistrates. So, Sarah, what about you? If you were Prime Minister, what would you do?
There should be almost a universal defence of reasonable excuse. So if you are saying, I did this action, here is why I did it, I am going to argue reasonable excuse. And to have that taken away by the judge before your case is heard means that you have been prejudged and you are now in court and not really able to defend yourself. So yes, being able to have a defence in court.
And I would just like massive restrictions on the imprisonment of people for non-violent offences, which includes protesters, but others as well. And that is it. Thanks, Audrey and Sarah. And if you want to find out more about protest law and some of the cases mentioned, do refer to our programme notes. Bye.
Goodbye.
Thank you. Goodbye.